If you want to get really, really good at what you do and offer value to your clients, get to know the financial institutions around you and how they deal with the power of attorney. A financial institution does not have to accept a power of attorney. They can just say, you know what, it's not our form. The other thing that you want to understand is what institutions have their own version of power of attorneys and want you to fill out. For example, the IRS. If you ever dealt with the IRS, you have to fill out their power of attorney in order to use it. You can send in a durable power of attorney all day and the IRS is going to just say, well, we don't care. We're just not going to deal with this issue. So get to know the institutions, and the institutions that do not listen to you or will not work with your power of attorney. I have found over the years we're moving in the direction of institutions just don't want to deal with it. They want a guardianship. They want some kind of court order. But a lot of institutions still out there will. Now, this is years of experience and many, many clients using power of attorneys and me, the experience that I get back from my clients. If I usually have somebody, African American, Hispanic, and they are going in and they're going to use a power of attorney, I have found bank and other financial institutions will give them a harder time. And that's something you want to be aware of. I'm not saying every institution out there does that. I'm not saying that well, I actually am saying it is common, but usually in that context, when I have an African American or Hispanic client and I hand them and I draft a power of attorney and then they go down to the bank, often far more than my white clients or an Asian client, the bank will go, well, we're just not going to use this. That's just a reality. I'm in the South, maybe that's it. I don't know what it is. But it's something that I am very aware of and that I really get to know what institutions I'm working with and talk to the institution about allowing that power of attorney to be used. I don't want to play the race card in any way, but it's very important to understand that it is a reality of the situation that your clients will deal with. And you just have to be aware of it and be able to draft the document in such a way that it's going to state on there, hey, financial institution, if you accept this power of attorney, there's no problems. But I want you to be aware of that and get to know the financial institutions in your area. So if they know you, they're going to be far more comfortable when they see that this attorney drafted this power of attorney. It's just like any institution. They just don't want to get in trouble. Last thing is title companies. Title companies have their own special rules when dealing with a power of attorney. For example, in Texas, if you're going to use a power of attorney, you have to have the property description in the power of attorney. It has to be filed in the county records, and 6 months cannot have elapsed since the signing of that document. That creates a serious problem when you're trying to use this in the context of incapacity planning. So you just are not going to be able to sell a house with just a power of attorney 5 years down the road in the state of Texas. But get to know. Call up your title company. Ask them what are the rules of a power of attorney so you're aware of them. Remember, title companies are the fourth branch of our government here in the United States.